Good morning, everyone. Welcome to those here in Carson City, as well as anyone in Las Vegas, and of course, anyone watching online through Nellis or YouTube. With that, Committee Secretary, will you please take the roll?
Assembly members Cole, Dahlia, Gonzalez, Gray, Hanson, Hardy, LaRue Hatch, Marzola,
Present.
Moore, Nadim,
Present.
Orentlicker, Roth, Urick, and Chair Miller.
Here. Just a few reminders before we get started today that asking everyone to turn down the volume on their electronics. Of course, we will have public comment at the end of the session, at the end of today's meeting. If you are planning on making a public comment or testifying on either of our bills today through the telephone lines, our phone number is 1-888-475-4499, and the meeting ID today is 830-4658-1952. We ask that anyone presenting a bill today keep their presentation to 15 minutes, and anyone testifying on a bill or making public comment keep their comments to 2 minutes. Of course, we also ask that before you speak that you state your name, and the first time you do so, that you spell it so that we have it correct for the record. We will have two bills today. The first one is Assembly Bill 172, which revises provisions relating to the disclosure of certain records stored on the internet. And with that, Assembly Member, we'll give you a few moments to get settled, and we are ready whenever you are ready to proceed.
Good morning, Chair and Vice Chair Marzola and fellow members of the Judiciary Committee and the Assembly. I'm Assemblywoman Alexis Hanson representing, let me spell that, ALEXISHANSEN, representing Assembly District 32. Today I'm joined by Lieutenant Jason Walker to my right and Detective Bradley Sage from the Washoe County Sheriff's Office. We will be presenting AB 172, which revises Nevada law concerning the disclosure of certain records stored on the internet. Some background information. As members of this committee, we are aware of the rapid advancement of technology and the increasing reliance on internet-based services, which have created challenges in the fight against cybercrimes, particularly those targeting our most vulnerable citizens, our children. Law enforcement agencies face significant hurdles when investigating these crimes due to the limitations of current laws that do not fully encompass modern technologies and communication platforms. Assembly Bill 172 seeks to address these challenges by expanding and clarifying existing provisions governing the disclosure of certain records stored on the Internet by providers of Internet service. This legislation is crucial in ensuring our laws keep pace with technological advancements, while aligning more closely with existing federal regulations, 18 U.S.C. 2701 through 2713, which already allows for subpoenas on social media accounts for cybercrimes against children. Social media platforms have become crucial sources of legally admissible data for criminal investigations, national security, and civil litigation. Law enforcement often relies on subpoenas to compel social media companies to disclose user information, including account details, private messages, and IP addresses. However, our current state laws have not kept pace with these technological advancements, hindering investigations and potentially compromising the safety of our children. By updating our statutes to encompass modern technologies and communication platforms, such as social media and messaging apps, AB 172 will provide law enforcement with the tools they need to effectively investigate and combat online crimes against children. This legislation strikes a careful balance between the needs of law enforcement and the protection of individual privacy rights. With the Chair's permission, I would like to now hand over to my co-presenters to give you a more in-depth overview of the bill.
Good morning, Chair Miller, members of the committee. I am Jason Walker, Jasonwalker. I work for the Washoe County Sheriff's Office. I'm a lieutenant currently assigned to patrol. I'd like to thank Assemblymember Hanson for allowing us to get to this point, as well as the chair's permission to present. We started this conversation mid to late last year, and to get it to this point, I'm very thankful for the opportunity. So again, in a nutshell, our NRS definition for internet service providers was established in 2007 and is in need of an update. AB 172 addresses this issue. The only internet service providers currently are AT&T, Verizon, and Comcast. The majority of persons nowadays are communicating by Facebook, Instagram, X, Snapchat, and other websites. AB 172's intent is to bring our current NRS definition into the year 2025 and further. It is my opinion this is a great companion bill to the Senate Majority Leader Canizaro's bill that she presented yesterday in Senate Judiciary, Senate Bill 263, along with Attorney General Ford. As far as AI, child porn crimes that are committed over the internet, as well as social media platforms. With me today, I have Detective Brad Sage. He has the why, how, and solution in our short PowerPoint, and with the chair's permission, I will now hand it over to him.
Good morning, Chair Miller and all members of this assembly. My name is Detective Bradley Sage, BradleySage. I'm currently assigned as a detective to the Washoe County Sheriff's Office. I investigate cyber crimes with an emphasis on internet crimes against children. With that capacity, I'm also a member of the Northern Nevada Internet Crimes Against Children Task Force, where we carry investigations across all of Northern Nevada anytime a crime is committed against a child with the use of technology or the internet. This presentation is going to do a quick outline about what we would like to see changed via Bill AB 172, and it will explain in definition why we need these changes. Obviously, at the end of that, I will be open to all questions and concerns you have. Let's get this run there. Here we go. So our current NRS lists internet service providers as any provider who provides subscribers with access to the internet or an electronic email address. This is somewhat of an archaic definition in the modern landscape of the internet, given that, as Lieutenant Walker stated, most communication across the internet now occurs via social media, which the user must facilitate the internet connection, but the social media platform facilitates the communication. This definition of ISPs and email addresses stems from a time when a person signed up through a provider and was given an email address. So for example, we all had a time we signed up and got an AOL address or a charter, something like that, when you got your first internet connection. Well, that's no longer the case now, because that email that you get from your provider typically is not the main one you use. Now, Gmail is the most popular email on the internet. Gmail is offered via Google, which in some states does offer internet service, not in the state of Nevada. Social media platforms do not provide access to the internet. As I stated, the user must facilitate that. When you want to have a Snapchat account, you have to provide your own internet access to get to snapchat.com and create the account. And this is where we start to see the gap that we have in what our NRS allows for subpoena and what we seek in our investigations to create probable cause and locate suspects. Nevada still carries this outdated internet communications view, and social media companies have started to deny any type of subpoena administered under the current definition of our NRS. And that's how we located this. The oversight that is already in place for administrative subpoenas worked. And these social media companies identified this gap in our NRS, and about a year and a half ago started denying any and all administrative subpoenas seeking user account details of suspect social media accounts, regardless of platform, Instagram, Snapchat, X, and so forth. So our solution to the framework I learned through my work as a FBI task force member using the United States Code. The United States Code 18 USC 2703 already governs what we can get through an administrative subpoena in terms of social media. And they encompass this through some language specifically not referencing an internet service provider or someone who gives you access, but referencing electronic communications provider or electronic communications service. And that can encompass anyone who offers the communication as well as offers the internet connection. So it kind of divides the problem we had of someone having internet connection and someone having Snapchat. This encompasses both. By mirroring this language, we're able to give law enforcement the ability to bridge this gap. So the problems we've run into, for example, in using a real-world case, is finding a phone at a dead child. So child homicide. We find a phone, they have an Instagram message resting on the phone. That in and of itself, seeing that the phone is locked, but there's an Instagram message, we do not possess probable cause to gain a warrant to ascertain the information related to that Instagram to see if it was related to a child homicide. With an administrative subpoena, that was how we would do it. We would submit an administrative subpoena to Instagram, find the user details for that one message, and see if that is a person of interest in the death of this child. And so right now, we have that gap in our investigative abilities to where we cannot establish probable cause because our current NRS, as I stated, does not encompass electronic service communications, electronic service providers, or remote computing. So by mirroring this language, we can get that in. As you can see on here, this is the entire 18 USC 2703. I'm not going to read it verbatim. The biggest portion here being that requirements for a court order or subpoena, and that's where we fall into it as law enforcement officers. This framework has been utilized in a variety of states to either adopt it into their state laws or the state law cites this code. For example, Virginia, Tennessee, and Oregon have all adopted laws that mirror this framework, and then other states such as Washington have laws that list that you should cite this code for their law enforcement ability to gain subpoena powers over electronic communications providers. So like as I said, electronic communications service, this is the key term. All right. Biggest portion on here is going to be the mirroring it from 18 USC 2703 on behalf or received by means of electronic transmission form or created by means of computer processing of communications received by means of electronic transmission form, a subscriber or customer of such remote computing service. So what that allows us to do is seek the subscriber information, which we already do in the state level for internet service providers. What that will provide law enforcement with typically is a name, an address, and most importantly, an IP address. As I'm sure you're all aware, IP addresses in the world of cybercrime are how we find things. An IP address is called an Internet Protocol address. What that is your mailing address for the internet. Just as every assembly person here has a mailing address for their home, your IP address is the address of the device which you are accessing that account from. And that is in the world of cybercrime is how we start to locate suspects and locate victims. So according to U.S. Code 2711, which is referenced in 2703, a remote computing service, defined in this provision to the public of computer storage or processing services by means of an electronic communication system. This means that any service offering storage or processing capabilities over the internet falls under this definition. This has to encompass, or we need this term to encompass social media because social media, all the computing power and all the electronic dissemination occurs on their server side. It does not occur within the state of Nevada typically. All major social media companies reside whether either in Texas, California, or a few other remote locations around the globe. And therefore, the remote computing is what we're after in terms of giving authority of law enforcement the ability to provide that subpoena to gain the results that we need. This is necessary with internet crimes against children investigations. We frequently see offenders try to move child victims from platforms that are harder to find if the child victim's device is viewed by a parent or guardian. So for example, a real life example would be a child predator finds a child on Snapchat. Snapchat is very well tracked. Snapchat is generally understood by most of the parents that we encounter. What they will do is have them move to a different platform that is harder or less known to a parent, such as Discord, such as Kik. A lot of these programs are unknown to the modern world because they're frequently used only by in-depth internet users or children. And then they can go through these platforms, try to stalk the child, meet up with the child, and commit other crimes through this platform, which the parent doesn't know exists or doesn't know how to access. All those platforms would be encompassed in this provision if the bill is adopted via either being an electronics communications provider or a remote computing provider. Because as I stated, all that processing and all that communication is happening on that company's server, on a Discord server, on a Snapchat server. So our solution as applied, you can see the changed language highlighted in blue. The electronic communication system means any wire, radio, electromagnetic, photo, optical, or photoelectric facilities for the transmission of wire or electronic communications, and computer facilities or related electronic equipment for the electronic storage of such communications. It also defines remote computing service, meaning the provision of the public of computer storage or processing services by means of an electronic communication system. So as I've gone over, this encompasses both facets that we seek to bridge that gap in our investigative abilities by giving subpoena power over an entity that offers either electronic communication system or remote computing. And those two terms are what we're going to utilize to encompass the current state of social media and also where it's going. The remote computing has become a huge element in the last 2 years because artificial intelligence is remotely computed. If someone wants to generate an AIG child pornography image, that's going to be an artificial intelligence generated image. They're not doing it on their local machine. They're doing it utilizing an AI engine that is happening remotely. So if we start to see images coming in that are AIG generated, we have tools that we can find the IP address or find the location where it was generated, but we don't have the ability to find the suspect currently without this provision. So as you can see, the changes included in this bill encompass both those terms. That brings us to the next step. That combined with other changes will modernize the NRS, giving specifically cybercrime the tools we need in terms of getting the data that modern social media represents, but it also expands to other investigations in the sense of where AI is going with the AI-generated child pornography. Obviously, there's other bills in session currently to address this problem, so that is a very new and very emerging front that we have already started seeing on the federal side. We have gained prosecution authority over those and have had successful prosecutions, and obviously we hope that the state of Nevada adopts similar provisions to allow for that at the local level, because we have seen it come up there as well. Yep.
Jason Walker for the record, and Chair Miller, with your permission, I'd like to go over the provisions of the bill, and after that, we can open up for questions.
Certainly. Lieutenant, I'm just thrilled this is the most we've heard you speak on the microphone all session, so please.
Glad I can make you all smile today.
Yes,
Thank you.
yes.
Jason Walker for the record. All right, Chair. Section 5 of this bill expands this definition to include a provider of internet service who provides subscribers or customers with a remote computing service. Section 5 thereby provides that a provider of internet service who provides a remote computing service is guilty of a misdemeanor upon certain circumstances, which are that the certain governmental entities can compel any such provider to disclose certain information. They also require any such provider to keep certain information confidential. Section 2 of the bill defines the term electronic communication system to mean any wire, radio, electromagnetic, photo-optical, or photoelectronic facilities for the transmission of wire or electronic communications, and computer facilities or related electronic equipment for the electronic storage of such communications. Section 3 of this bill defines the term remote computing service to mean the provision to the public of computer storage or processing services by means of an electronic communication system. Section 4 of this bill makes a conforming change to prescribe the applicability of the definitions set forth in Sections 2 and 3. And with that, Chair, that ends our presentation, and we will happily take any questions.
Thank you so much. Our first question is from Assemblymember Roth.
Thank you so much, and thank you for the presentation. I just want to make sure that I'm understanding. This does not take any of the work outside of a warrant requirement. Is that correct?
Bradley Sage. This is a building block that we utilize to gain probable cause for a warrant. So the data we would receive from an administrative subpoena would be one of the steps to establish probable cause. But in those investigations where we have not met probable cause based on the information we have concerning social media, this is how we get to that step.
Thank you for the follow-up, Chair. And then I'm just curious where the gap is. I'm looking at NRS 205.4744, and that defines internet or network site, which includes any similar site on the World Wide Web. And so has that not been able to be utilized currently?
No, the NRS only allows for us to subpoena results from ISPs. It specifically delineates internet service provider, which is someone who offers the physical connection. The powers are limited solely to that, and that's why our reason for expanding to the electronic communications provider. Sorry, Bradley Sage, for the record. My apology.
Our next question is from Assemblymember Cole.
Good morning. Thank you. I always appreciate gap fills, right? Because we always have those. My question is there a way for us, instead of, maybe in addition to defining the terms, maybe reference the USC that you cited so that if that changes, our laws automatically shift and move and have that same flexibility? And I don't know, maybe legal can answer that question too, if that's frowned upon.
Yeah.
Carly O'Krent, for the record. You could amend the bill to do that, or you could leave the bill codifying that federal provision. Doing both would be, I think, incomprehensible for the reader. I think it's a policy decision, and there might be folks in the audience that could speak to that policy decision, or the assembly member.
Bradley Sage. I believe that's codifying the code into the NRS is the better choice, solely as it eliminates any kind of lag time from the federal side being updated to the NRS, given the speed that technology changes. As we've already seen, AI in the last 2 years has taken a slew of advancements, some in the realm of crime, and the laws have a hard time keeping up with this. It's kind of reminiscent of when the methamphetamine exploded and laws kept changing, trying to ban the chemical composition of methamphetamine, not the concept of methamphetamine itself. And you can change one molecule and still make methamphetamine. Same thing happens here. If you ban the specifics in terms of one AI site or one Snapchat, or you reference one piece of technology, technology changes too fast to key in. The legislatures have a harder time keeping up with it because of the speed of advancement.
Thank you for that. Our next question is from Assemblymember LaRue Hatch.
Thank you, Chair. Thank you for being here this morning. So I definitely appreciate the sentiment of updating our statute, because we need to do that quite often. I just want to confirm, though, this is not changing any of the oversight or safeguards or any of the legal requirements for gathering evidence. It's just updating the technology terms within the statute.
Jason Walker, and thank you for the question, Assemblymember Lewer Hatch. That is absolutely correct. We already have the clearly established 18 USC language. What we want to do is bring our internet service provider language to the current. So you are correct.
Okay, I don't see any additional questions. So with that, we'll go ahead and open it up for testimony. So beginning here in Carson City, anyone that would like to testify in support of Assembly Bill 172, I ask that you say your name, spell it, and also please try to keep your comments to 2 minutes each.
Good morning. For the record, my name is Jennifer Noble, Jennifer Noble, here in support of Assembly Bill 172 on behalf of the Nevada District Attorneys Association. And we'd like to thank Assemblywoman Hanson for sponsoring this important bill that seeks to bridge a critical gap in law enforcement's ability to continue investigations into cyber crimes, particularly against children, as they need to in the 21st century. And in thinking about the 21st century and trying to understand how all of this works, I was thinking a little bit about the 20th century, and I'm going to age myself here today. But some people in this room may remember landlines and phone books, and I remember as a kid, if I wanted to look up a friend's information that I met at the swimming pool in Lovelock, Nevada, I would find out what their mom or dad's name was, go back to my grandma's house and look up that information. It had their name, it had their address, it was a book everyone had in their home. This subscriber information that they're seeking is no different in terms of privacy invasion and simply the subscriber information, name, address, and IP address. It's not the content of the messages. So I'd ask you to think about it in that context, perhaps. Internet crimes against children flourish in darkness and anonymity, and this bill simply allows law enforcement to obtain that information, name, address, IP address, just like I could do with my friends I met, and they can conduct the type of investigations that parents of children in Nevada, including myself, expect and want. I think that Assemblymember Cole's suggestion about incorporating this federal statute by reference is an excellent suggestion because it allows us to continue to keep up with the times. But we do support the bill as written today. Thank you.
Good morning, Chair, members of the committee. Jason Woodard, Jason Woodard, Nevada Sheriffs and Chiefs Association. We're in strong support of AB 172. During the course of these types of investigations, it's a benefit to society that technology evolves so rapidly and so quickly. However, the challenge that you folks are faced with is that we, from time to time, as was spoken earlier, statutes and laws need to be updated in order to keep up and catch up. Not all digital platforms are 100% cooperative with law enforcement and their investigations. And sometimes when we have these language loopholes, it can stymie or stall an investigation for a prolonged period of time. And the challenge with these particular investigations is twofold. One, the information is rapidly transmitted, meaning those images can be, if there's images in that particular case, they can be distributed very rapidly and very widely. In addition to that, information can time out, can be lost, or it can be purged. So having the ability to streamline investigators' capabilities in eliciting this information and ultimately going through the process of demonstrating to a court that they have probable cause to obtain a warrant will make some of those challenges diminish and go away. But I'm relatively certain that we will continue to have to keep up with technology and continue to ask for updates as time goes on. We'd ask that you'd support this bill. Thank you.
Good morning, Chair and members of the Judiciary Committee. My name is Joshua Martinez. I represent the Las Vegas Metropolitan Police Department, JOSHUAMARTINEZ, and I'm here in support of AB 172. And I just echo all of the concerns and information that was presented already. As well, this would just help us provide another tool in the toolbox and keep up with technology in the times that we're in today. Thank you.
For the record, my name is Dan Gordon, D-A-N-G-O-R-D-O-N. Good morning, Chair and members of the Judiciary Committee. I'm the president of the Nevada Police Union, and I represent the Nevada State Police officers, including the Nevada State Police Investigation Division, and we are in full support of AB 172. Thank you.
Thank you, Chair, members of the committee. For the record, Mike Cathcart, representing the City of Henderson, C-A-T-H-C-A-R-T. We're in support. Ditto to comments.
Thank you. Not seeing anyone else here in Carson City, is there anyone in Las Vegas that would like to testify in support? Not seeing anyone approach. Broadcasting, will you open the lines, please?
Public lines are open and working. There are no callers at this time.
Thank you. Then I will open it up for testimony in opposition of Assembly Bill 172. Is there anyone here in Carson City? Not seeing anyone. Is there anyone there in Las Vegas that would like to testify? Not seeing anyone. Broadcasting, will you open the lines?
The public lines are open and working. There are no callers at this time.
Thank you for that. Then I will open it up for neutral testimony, beginning here in Carson City. Not seeing anyone. Is there anyone in Las Vegas? Also, with no one approaching, broadcasting, will you open the lines?
The public line is open and working. There are no callers at this time.
Thank you. Then I will go ahead and close testimony and welcome the bill presenters back up for any final brief comments.
Alexis Hansen, Assembly District 32. In conclusion, AB 172 would allow our laws to remain relevant and effective in this digital age and provide law enforcement with the necessary tools to protect our vulnerable populations from online predators and exploitation. Chair, I'd like to thank you and the committee for your thoughtful consideration of this bill. And if it would be okay with the chair, I'd like to have some closing remarks from my presenters.
Bradley Sage, I would appreciate your support in this bill. Our task is very difficult in crimes against children. It is an ever-changing world. The technology moves faster than even our own technology can keep up with it. A new device comes out, a new phone, a new operating system. We have to learn new ways to get into it, new ways to work the forensics on it, new ways to track suspects through the internet, through an ever-changing series of tubes. This bill represents something once that I got told by a teacher at a young age. With the onslaught of technology, it's like an ocean hitting you, wave after wave after wave. And I had a teacher once tell me, you can fight the ocean all you want, or you can learn how to surf. And in my opinion, this is that concept. This bill adapts the language, so we're not just fighting the ever-hitting waves of technology, and we can start to learn how to surf through it, adapt to it, and gain what we need out of it, given the proper authorities and proper oversight. Thank you.
Jason Walker, and lastly, Chair Miller, thank you again for the opportunity to present AB 172, and I'll close with this. With the rapid advancement of AI, artificial intelligence, the tech, the child and persons exploitation that's being committed along the social media platforms, AB 172 does not change any oversight in our subpoena nor warrant processes. With the passing of AB 172, it gets the great state of Nevada current and in the game to thwart and or combat these crimes. Thank you.
Thank you so much. And with that, I will go ahead and close the hearing on Assembly Bill 172. Next on our agenda today, we have Assembly Bill 460. Assembly Bill 460 revises provisions relating to child welfare. So I will give the Assembly member a few moments to get settled, and then whenever you are ready, you may proceed.
Good morning. Thank you, Chair Member. Thank you, Chair Miller and members of the Judiciary Committee. For the record, I am Assembly Member Cecilia Gonzalez, and I represent Assembly District 16 in Clark County. Today, I'm presenting Assembly Bill 460, a bill that ensures that children in Nevada are protected and will remain with trusted caregivers when their parents are faced with unexpected separation. Regardless of where we stand on immigration policy, we can all agree that children should not bear the brunt of these challenges. When a parent is suddenly detained or deported, their child's world is turned upside down. These children experience fear, instability, and deep uncertainty about their future. As policymakers, we have a responsibility to provide solutions that prioritize family unity, stability, and the well-being of our most vulnerable children, and AB 460 does exactly that. Nevada is home to one of the largest populations of mixed-status families in the country. Nearly 1 in 10 households includes a U.S. citizen, children with an undocumented parent. That means that in every single one of our districts and the people that we represent, there are hardworking families that pay taxes and contribute to our community, yet live with the daily fear of separation from their parents. When a parent is taken away, their child can be left in legal limbo, often with no clear plan for who will take care of them. Some end up in foster care unnecessarily, placing additional strains on our already burdened child welfare system. Others face disruptions in their education, their health care, and their emotional well-being, making it harder for them to succeed. And studies show that family separation causes long-term emotional trauma, increasing risks of anxiety, depression, and PTSD. These are not abstract policy discussions. These are about real children, real family, and the real harm that we have the power to prevent. AB 460 is practical and ensures that parents can plan for their child in the event of separation. I will now walk through the sections of the bill. I do want to note that there is an amendment that has been posted on Nellis that I will walk through as well. There's also been some concerns about Section 1 that we are working to massage as well. Section 1 establishes a form by which a parent or guardian may request to nominate a guardian for a minor. The Secretary of State is required to make the form available on its website. In addition, Section 1 provides that the person nominated for the appointment as the guardian of a minor must file a petition and obtain an appointment from the court before exercising the powers of a guardian. Section 4 authorizes this form to be filed in the Secretary of State Nevada's lockbox, providing a secure and accessible way for parents to express their wishes regarding their child's care. Section 3 requires a court to consider the form requesting to nominate a guardian of a minor in determining which person is most suitable to be the guardian for the minor, while Section 5 authorizes the Secretary of State to provide access to the lockbox when required by a court, hospital, law enforcement agency, or other entity that needs to determine whether a person has designated a guardian for a minor. Section 2 creates a presumption that temporary guardianship is in the best interest of the minor when no parent has care, custody, or control of the minor due to separation caused by a federal immigration order. This provision addresses the unique challenges faced by families impacted by immigration enforcement. Section 6 expands eligibility for supportive assistance through the program that provides such assistance to relatives who care for and obtain legal guardianship of the child. Specifically, it allows relatives who have not attained the minimum age set by DHHS to receive assistance if they are the legal guardian of a child separated from parents due to federal immigration order. And finally, Section 8 includes an appropriation to the Department of Education for the Nevada Trauma Recovery Grant Fund, supporting children affected by trauma through clinical trauma-specific interventions. I will now address the amendment. The amendment that's posted on Nellis will delete the provision in which the Secretary of State can charge and collect fees for registering these documents. The amendment retains the Secretary of State's ability to accept gifts, grants, and other contributions for the purpose of maintaining the Nevada lockbox. And there was an amendment, part of the amendment is to delete Section 8, which is the appropriation to the Nevada Department of Education. It's not lost on me the conversations that we've been having in our state's budget about what that is going to look like this session and beyond. And so the amendment was proposed to remove that, but if we have the opportunity to include that, we would love to. And so we're still having those conversations, but that's why the amendment was to delete that section. I have Jonathan Norman here with me, who will have a few words. Chair, with your permission. Thank you.
Chair, members of the committee, Jonathan Norman, NORMAN, Nevada Coalition of Legal Service Providers. When this bill came out, we shared it with the Nevada Guardianship Commission just to screen the language. And in Section 6, subsection 4, I would anticipate an amendment that's to meet the needs of these families a little tighter. And the example I'll give is in that provision, it creates a presumption, which is a very strong thing. And you can imagine a scenario where one parent is unavailable and you may not want to trigger that presumption. So just to address that, the Guardianship Commission is working on it, and we should have language early next week.
Thank you so much. And with that, we are ready for questions.
Thank you. I'll give members a few moments to generate any questions they may have. Our first question will come from Assemblymember Cole.
Good morning. Thank you for this. So my question is on section 3 at the top of page 4, where you are providing that form, and it's for the witnesses specifically. So it says, I declare under penalty of perjury that the principal is personally known to me. So I'm just curious, is that a requirement that whoever the witnesses are actually knows the person who is giving the guardianship or signing the document? Or could it be somebody that, you don't know that well, but they're willing to say all of these things? I'm just looking at it from the will formalities and how those work. And then secondarily on that same form, it would be very difficult for this notary block to work unless you had both witnesses signing the document in front of the notary at the exact same time. So I would probably separate those two signatures out with two different notary blocks. And I'm a notary, so that's why I'm saying it. Thank you.
Jonathan Norman, Assemblymember Cole, thank you for the question. I hadn't given much thought to your first question, which is, I declare under penalty of perjury, the principal is personally known to me. I think they probably would be under that language. I have up on my screen, the legal aid providers have family preparation kits for a variety of things. So we have a nomination of guardianship form there. And in just looking at it, we have teased out for your second question, the notary line. So maybe we can share that with the sponsor and see if maybe the language that we're using might fit better. I don't know if this was from the Secretary of State's office or.
Cecilia Gonzalez, thank you so much for the question. I definitely will get with the stakeholders and looking at that. I think the intent is definitely giving parents the right to choose who they are, or giving parents the options to choose who they want. I think in practice you would want somebody that right? And so maybe that was the intent of how it came out of drafting, but we will definitely look more into that. Thank you.
Thank you. Our next question is from Assemblymember LaRue Hatch.
Thank you, Chair. Thank you for bringing this important bill this morning. I really appreciate the need for this. My question is, I noticed that in the bill it says the Secretary of State will adopt regulations to carry out the provisions. Are you anticipating then that the Secretary of State is the one that would advertise this to folks, that would make it available in other languages? I just want to make sure folks have access to it, and just wondered what the plan was on that.
Cecilia Gonzalez, thank you so much for the question. I appreciate that. I think that our caucus and our legislators do a really good job of taking the things that we pass in our community back to our communities. Many of us hold town halls. Many of us are really involved in the community. And so I think that the information will definitely get back to them. I don't know if we necessarily thought all of that through. I think getting through this hearing, getting through the next steps, right, and passing the bill. So that's definitely a good suggestion that we can look into. Thank you.
And
Assemblymember Gonzalez, if I may.
Oh, and Gabriel. Apologies, Chair. Gabriel's down south.
Gabe, I don't want to say that none of us noticed you were there, but I think that I'm sorry. Deputy Director, I'm not going to say that the bill sponsor also didn't realize you were there. But we appreciate your interjection. So please continue.
Thank you very much. And if I could hold up some kind of Wile E. Coyote sign in the future, I'd be happy to do so. Gabriel DeCara, for the record, Chief Deputy Secretary of State, just hopped in because we were mentioned. Presently, although the Secretary of State's office does advertise the Nevada Lockbox program, we do so hand in hand with a lot of the key stakeholders in the community. So, for example, a lot of the current guardianship provisions in the Lockbox relate to seniors and older folks, and so we do a lot of work directly with, for example, AARP. There are a lot of senior groups that we do outreach to, and then those groups in turn do direct outreach to the potential users of the lockbox. The Secretary of State's office would absolutely look at who we should partner with to make sure that word gets out about this program, the service that we could provide, et cetera. Thank you.
Thank you so much. And Vice Chair, I apologize. I do have Gabriel with me. We did check if he was there. And then I also have Senator Degnote with me. He has been working on this bill with me and stakeholders as well. And so he would, with your permission, like to say a few words as well.
Please.
Thank you so much, Vice Chair Fabian Nanyate, for the record. One of the things that I wanted to respond to the Assemblywoman's concerns is, you know, Assemblywoman Gonzalez and I worked a lot on this bill within the last few months, of course, as this conversation has become more relevant. This actually came from the community members. This was a recommendation specifically from them. And so I think there's some value of the fact that individuals were coming to us with this solution. And so that's why we're putting that bill forward. It's not a situation where the reverse, where we're trying to get folks to understand this legislation. It was quite the opposite. And so I hope that because we're responding to the needs of what folks are worried about, this is going to have more of a greater relevance than we have in other bills. So thank you for that.
Committee members, any additional questions? I don't see any. I do have a quick question, and guardianship is not my space, so this is just for clarity. This would work as a temporary guardianship. So say for some reason, God forbid, the parents were never allowed back in the country. Would this turn into a permanent guardianship? Would an adoption be available for the guardians at that point? I just want to make sure that, you know, the whether it's the estate or the kids, that it's covered from day one to...
Jonathan Norman, for the record. So the temporary guardianship provisions are .052 and .053, and they're for 10 days initially, and then there needs to be a hearing, and they can be extended for up to 120 twice, 60 days at a time. And then in addition, under extraordinary circumstances, that temporary can go longer. But in that time, if a parent is still not available, the temporary guardian would need to file for a permanent guardianship. Now, when we say permanent guardianship, that's not permanent. A parent still retains their parental rights, and they can move to terminate that guardianship if they're available in the future or if circumstances change. So.
Thank you for that answer. I just wanted to make sure that, you know, when we're talking about children, they're not going to end up in foster care for some reason when we can help that. So that was my question. Committee members, last chance. I don't see any additional questions. We will move to support testimony. To Assembly Bill 460, is there anyone here in Carson City wishing to testify in support? I don't see anyone. Is there anyone in Las Vegas wishing to testify in support to Assembly Bill 460? I don't see anyone. Broadcast. Oh.
Sorry.
Were you going to testify in support? Even though
I
you're
sure was.
also the presenter? Okay. You have 2 minutes.
Gabriel DeCara, for the record, Chief Deputy Secretary of State. I am testifying in support on behalf of Secretary of State Francisco Aguilar. Secretary of State Aguilar supports this bill. He's excited about the use of Nevada Lockbox to provide more services to Nevadans. We are grateful to work with the sponsors of the bill. And I just wanted to note that the provision in the bill that removes the Secretary of State's ability to charge for the Nevada Lockbox, that language was placed in at the creation of the lockbox, and the Secretary of State's office historically has never charged for this service. We don't intend to, and frankly, we don't think it should be a charged service, and so we support that language as well. Thank you very much.
Thank you for your support testimony. Is there anyone else in Las Vegas wishing to testify in support? Broadcast, is there anyone on the line?
If you would like to testify in support of Assembly Bill 460, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 542, please press star 6 to unmute your phone. You may begin.
Good morning, Vice Chair and members of the committee. This is Jeff Rogan, Jeff-R-O-G-A-N, from Clark County. We are in support of this bill. As written, this bill provides additional mechanisms for parents to be able to plan for the protection and care of their children. This would have a positive impact on reducing the number of children for entering the child welfare system in Clark County in the event that a parent is no longer able to care for the child. We thank the sponsors for bringing this bill forward. Thank you.
Vice Chair, there are no other callers wishing to testify in support at this time.
Thank you. We will move to testimony in opposition to Assembly Bill 460. Is there anyone here in Carson City wishing to testify in opposition? I don't see anyone. Is there anyone in Las Vegas wishing to testify in opposition? Broadcast, is there anyone on the line?
The public line is open and working. There are no callers to testify in opposition at this time.
We will move to neutral testimony. Is there anyone here in Carson City wishing to testify in neutral? Don't see anyone. Is there anyone in Las Vegas wishing to testify in neutral? Broadcast, is there anyone on the line?
The public line is open and working. There are no callers at this time.
Assembly member, would you like to give any final remarks? I will now close the hearing on Assembly Bill 460. I will now open up for public comment. To provide public comment or testimony, call 888-475-4499. When prompted, please provide the meeting ID 830-4658-1952 and then press pound when prompted for the participant's ID. As a reminder, the time for testimony on the bills we heard today has passed. Please address your remarks to issues that fall within the jurisdiction of this committee. Also, as a reminder, public comment is 2 minutes. Is there anyone here in Carson City wishing to provide public comment? Don't see anyone. Is there anyone in Las Vegas wishing to provide public comment? Broadcast, is there anyone on the line?
The public line is open and working. There are no callers at this time.
Thank you. Members, are there any comments before we adjourn? I don't see any. Our next meeting will be held on Friday, March 21st. Our time is 8 a.m. This concludes our meeting for today.